Hi everyone, welcome to the Social Talks. I am your host, Vishnu Ranabothu, and today's story is about the Supreme Court ruling on Section 230. For some background information, Section 230 refers to a provision in the United States Communications Decency Act, or the CDA, of 1996. It is a critical piece of legislation that grants certain liability protections to online platforms for the content posted by their users. Under Section 230, online platforms such as social media websites, are generally not held legally responsible for the content created and shared by their users. This means that if a user posts defamatory, offensive, or illegal content on a platform, the platform itself is shielded from most lawsuits related to that content. Additionally, Section 230 allows platforms to moderate and curate user-generated content without being treated as publishers or being held liable for the content they choose to remove or moderate. This provision has played a significant role in fostering the growth of user-generated content platforms and enabling free expression online. However, it's important to note that Section 230 does not provide absolute immunity for platforms. It includes exceptions for certain types of content such as intellectual property violations and federal criminal law. Platforms are still expected to comply with other laws, such as those related to copyright infringement and illegal activities. Section 230 has been the subject of ongoing debate and scrutiny in recent years. Critics argue that it grants too much power to platforms, allowing them to avoid accountability for harmful or misleading content. Some argue for reforms to hold platforms more responsible for content moderation and to address concerns related to misinformation, hate speech, and other problematic online behaviors. Now that this information has been established, it is important to know that what the Supreme Court has actually ruled on Section 230. The question of whether Section 230 of the Communications Decency Act shields businesses like Google and Twitter from claims that their recommendation engines encourage terrorism has been deferred by the Supreme Court. The court ruled that the families of ISIS assault victims did not claim that either tech corporation had willingly supported the terrorist group in violation of the Anti-Terrorism Act in Gonzalez versus Google and Twitter versus Tomne, two recent rulings. The Supreme Court no longer had a reason to rule on whether Section 230 shields computer companies from accountability for liabilities produced or assisted by their recommendation algorithms in the absence of a valid claim under the Act. This case demonstrates that big tech companies are firm enough to win cases without using excessive assistance from Section 230. I am Vishnu Ranabothu, and for more news and updates, you can always find us at thesocialtalks.com. Have a great day, and thanks for tuning in.